Hello, my name is Tim Callgreen, Director of Civic Education at the Indiana Bar Foundation. And with me today, we have Renee Ortega, who's an attorney with the Rock Legal Group in Crown Point, Indiana. And we're going to have a conversation about direct examinations. Ms. Ortega is an attorney licensed to practice since 2008 in both Indiana and Illinois. Her primary practice focuses on family law. She also works for the Hammond Legal Aid, as well as the public defender for Lake County Juvenile Court. She lives in Northwest Indiana and active in the Lake County Bar Association, Northwest Indiana Hispanic Bar Association, Indiana State Bar Association, and the Women's Lawyers Association of Indiana. Ms. Ortega earned both her bachelor's degree and law degree from Valparaiso University. So Renee Ortega, it's great to have you talking with us today.
Thank you for having me.
So as mentioned before, we're going to talk about direct examinations in a trial. And so as with any element in trial and in mock trial, there isn't just one right way to do this. So we're going to have a conversation with an expert on a way to help your mock trial team do this as a way to do this. And let's start with this. Since we're talking about the trial element of direct examination, what is direct examination and how and when is it used at a trial?
So what I like to think of direct examination is basically it's a way for you to present to the court or a jury your side of the story. You're presenting your case, your explanation of what happened, what didn't happen, or what should have happened. So I look at it as you're usually the plaintiff or the person initiating the case. So generally in civil cases, you're the one who goes first. You get to say, why are we here? What is going on and what are you wanting from the court? What relief do you want, or what exactly is, why are we here? And so it's your chance to tell your story, and you get to go first, and you get to share all the details and give everybody the first glimpse at your case.
And so let me ask this, you talked about it being first in the trial there, one of the things that you're telling your story from the prosecution plaintiff point of view, is it the same thing on the defense side? You're trying to tell your story? So
in a way, yes. If you're doing a criminal situation, usually the state goes first because they have the burden of proof. And so it's generally whoever has the burden of proof gets to go first, but it's when you're presenting your side of the case. So whether you're the plaintiff or the defendant, whether it's a criminal case and you are the defendant, or plaintiff respondent, petitioner respondent, this is your chance to present your side of the story. So, the plaintiff goes first, and now it's your time to say, okay, well, they said this, but actually what they have to prove is this, and they can't prove it. And here's why, and let me tell you, what happened, in my own words and in my own way.
Oh, great. So you're getting, like, I know it's repeating, but each side's through their own lens, they're telling their story through the direct examination of a witness. So as you're talking to a witness, I've liked to say, as I talk with mock trial teachers and students, that it's witnesses that get to tell the story. So tell us why we have the witnesses and the witnesses' role in a direct examination in a trial.
So basically, you're going to have your main person, who is usually the plaintiff, the defendant, the petitioner respondent. They're the main person that the case is usually about. But normally, it's not just two people that make up a case. There's usually all these other people that are involved somehow. So witnesses are there to help give credibility to your main person. They can also be people who actually were there and saw what happened and can verify, oh, yep, I saw this with my own eyes, I know what happened. Or they can just present kind of pieces to the puzzle that helps fill in, your big picture. So usually when you're presenting a case, you're wanting to present, show the court how everything fits together. And so sometimes witnesses can help fit those pieces together. Your client may not have the whole story, because some of what they might be saying would be what would be considered hearsay. So some of how you get that stuff in is by presenting the evidence or the testimony directly from that witness.
Witnesses build the puzzle pieces. They're what puts the story together. I can see that analogy there too, but let's look at the attorney then. What does an attorney do, or what's their role in a direct examination if the witnesses are the ones telling the story?
Well, the attorney is the one who helps guide everybody. So, and this is a lot of times what you'll see when people don't have attorneys, so pro se litigants, all of a sudden you'll just have everybody talking about anything and everything. An attorney is there to help direct and narrow that process, because there are certain things that are important to your case and that are not important to your case. And sometimes people who don't practice don't really understand that everything that they're saying to you is not important to proving what you need to prove. So an attorney is there to help the witnesses, kind of the client, direct the flow of what they're saying so that the testimony that is being offered is to the point and relevant. Because the last thing you want to do is have the court or the jury going off on all these tangents and missing the point, because you've spent 20 minutes talking about something that's not relevant. So the attorney is kind of like, almost like the ringleader of the circus.
They're the map
lead you
maker.
down the path.
They're the map maker. That's the way I'm kind of thinking there too. That helps us scout on the map. All right, great. Now I think of the attorney as they're asking the questions of the witness. There are certain ways they have to do that, because there's in the rules you can't ask certain questions or ask certain types of questions. So briefly, how does an attorney ask the questions? And I know maybe the difference of leading or non-leading questions.
So on direct, you are not supposed to ask what are called leading questions. And a leading question is a question that can only be answered with a yes or a no. So a leading question would be, did you go to the store last night? And that's a yes or a no. An example of a non-leading question would be, what did you do yesterday evening? Or what did you do last night? That allows the person to answer without a yes or no. Now, there are some times where you can get away with asking leading questions if it's like a very simple, question that's just helping move things along. But for the most part, when you are doing your direct examination, the questions should all be very open-ended. They should be allowing the witness or your client the opportunity to tell their story or what happened in their own way. But that's where trial prep comes into play, is because you want to have kind of prepped your client to say, okay, here's what I'm going to be asking. Let's go over what you're going to be saying. That's not to say that you tell them what to say, but you kind of help them understand, like, okay, I'm going to be asking you these kinds of questions. What would you say? And then that gives you an idea of kind of how to frame your questions, maybe where to go with some of this stuff, kind of talk to them about, okay, well, we don't need to get into that because that might be for later, or that's not relevant. And it kind of helps them prepare for that day.
So the way I kind of hear it back to some of the analogy is that attorney helped make the map and we're trying to walk down that path, but it's the witness that needs to take that walk, tell us that story through their testimony, and the attorney can't ask those leading questions, or typically can't ask those leading questions to walk us down. It's the witness that tells the story.
Right, the attorneys can't testify. So, when we're doing the direct examination, cross-examination is where you ask the yes or no questions. On direct, again, the whole point is to let the witness speak what happened.
Great. In mock trial, we also work with a redirect examination, which sounds the same, but it's a different part of there too. Can you explain the difference between a direct and how we get to the redirect and maybe how you use that at a trial?
So direct, obviously, as I said, is when your witness gives their testimony. Then the other side has the opportunity to cross them on what was said. And so when the other side has finished with their cross-examination, sometimes the questions that they ask almost give an inference of something. And so you'll have your client or a witness try to like wiggle out of the question and explain it. And sometimes they'll get shut down either by the judge or the attorney because, oh, Mr. So-and-so, it's just yes or no. So is that a yes or a no? And so you want to let your client know, don't worry, just answer the question because I will have an opportunity to go back and kind of clean that up. So redirect is your opportunity to kind of maybe clean up or clarify something that maybe came out during the cross-examination that you feel needs a little bit more explanation. It's not giving any new information because you are limited to what was already talked about. So you can't come back and be like, oh, I forgot to ask you this question. No, you have to stick with what was already said, but you can clean it up or maybe allow your witness to explain what exactly they meant when they weren't allowed to on cross.
I think maybe back to that analogy, the attorney can help get us back on the map that they wanted to present, where the cross-examining attorney was trying to take them on a different map and a different path.
Yeah.
Oh, great. So along those sides, as you talk about, you might have to rehabilitate or help out that witness in there too, because something we got onto that other map, the cross-examination attorney did that. So I think every witness has something that helps your side and hurts your side of the case. So as you're working on your direct examination with your witness, do you maybe have suggestions on how to reinforce the good or minimize the bad or get us back onto the path you want to take?
So I am always of the mindset that if you do have something bad, if your client has something or a witness has something to say that might not be great, or I don't know, that you feel might put them in a bad light, I always like addressing it indirect because I always feel that it's better to be forthcoming with the court and the jury and to say, you know what, yeah, my client or witness did this or said this, but here's why that doesn't matter, or here's why that shouldn't have you have a bad impression. And I always feel that way because it's better. I think we as people sometimes look at it as, oh, you were being forthcoming. To me, that means you're more credible rather than it coming out in cross. And then it almost makes it look like you were trying to hide something, or that, you were being sneaky and didn't think that it was going to come out. So I always find it easier to kind of address some of those things head on, because again, on direct, you can kind of lead that conversation. You can kind of frame it. And then, yeah, on cross, they can talk about it, but it's already kind of out there. You've already addressed it. They can kind of try and twist it, but then you can clean it up again. So I always find that it's better to address those things head on, because then you can craft the story that you want people to hear right off the bat, rather than having to almost like come back later and clean it up.
I think that's a great tip to just kind of just put it out there, be forthcoming and try not to hide the ball, because the other attorney has the option to bring it up too. So I guess it makes me think, do you have any other tips that you typically use for a direct examination, or tips or rules that you like to use?
I would say on direct, you want to keep in mind what it is that you are trying to prove. So either what element of the statute, so if you have the burden of proof, making sure that you are hitting all those points, or whatever witness is supposed to be presenting that piece of the puzzle, that you are making sure that you are hitting those points. So sometimes, depending on the case, I don't write out my questions anymore like I used to when I was a newer attorney. But sometimes, depending on the case, or if it's something that I haven't done before, I will kind of write an outline to remind myself when I'm going through the questions, oh, make sure that I remember this is what we're proving, this is my burden, because you just want to make sure that you are actually, once you're done with, once you're, the court asks you, have you rested, that you have proven everything that you've needed to prove.
I think that's great. Obviously, you got an end goal and there's a checklist that you need to do and have that ready to go. So I guess maybe my final question is there anything we didn't cover or is there something that you think our mock trial advisors and students should know about a direct examination?
I would say that a direct is your way of showing that you know your case. And so, you want to be as best prepared as you can be, because you are the one who's, driving the show. And so the more prepared and the more that you know your case, I almost want to say the easier it is, because there are no surprises. Like who said what, what your witness is going to say, all the evidence, the facts. And so the more prepared you are, the more you've kind of gone over everything, you have your outlines ready for each of your witnesses, I think the more successful you will be.
Oh, I think that's so great. And great tips, great conversation. Renee Ortega, thank you so much for having this conversation and informing our mock trial advisors and students watching about the element of direct examination. We really appreciate it.
Thank you. I hope it was helpful.
It was great to listen to. Thank you so much.
All right, thanks.